rise. The Court of Appeals Division 1 is now in session.
You may be seated. Good afternoon. We're here today in our case number CACV230698, Voice et al. Versus Hall. Each side will have 20 minutes to present their arguments, and I understand Dominium is not requesting any additional time for rebuttal or to reply on the cross appeal. These proceedings are being recorded, both audio and video, and we request that you state your name and who you're representing when you start. It helps us identify if someone's listening to a recording. We have conferenced this matter. We've read the briefing that was submitted. We appreciate how thorough the briefing was. We have discussed this matter, but we think we're familiar with the facts and the issues. We hope we are, but we're looking forward to your argument. And with that, counsel, you may begin.
Thank you, Your Honor, and may it please the Court. I'm Timothy Lasota here on behalf of Voice of Surprise and Quinta Schultzka, who's here sitting at the desk next to me. And I would like to reserve 4 minutes for rebuttal. I don't know if it's my job to kind of keep track of time, but I wanted to mention that at the outset. And in terms of this case, obviously we've got the two issues. We've got legislative versus administrative, and we've got the laches arguments, a number of sub-issues related to those. As far as legislative versus administrative, I think in terms of what they did in 2008, I think it's pretty well spelled out in the briefs. It was an extremely limited action, so limited that just about anything that they did subsequent was going to comply with what they did.
I would like to ask you about it. There are some parameters in 2008. You would agree it's not just a complete blank slate. There are some parameters?
Your Honor, the parameters are, the answer is yes, but it is about 2/3 of the zoning code. So, I think the more interesting question is, what if they would have just said, hey, this could be, we're going to rezone this thing to every single zoning district in the zoning code, and now you're on notice that it could be any one of these things, and we've done the legislative act previously. As it is, I think it's either 10 out of 15 or 11 out of 16 zoning districts they covered. I think there's two things that's very telling about why it is legislative, and that is, if they were under Surprise's code, if they were to go from, I think it's R18 to R12, that's essentially 2.4 houses per acre to 3.6 houses per acre. That would be a rezoning. That would clearly be a legislative. It would be referable. Here, they get to decide exactly how many houses to allow on this entire piece of property. Anywhere from R143, which is 1 per acre, to the most dense district, which is 21 houses per acre. Anywhere on that spectrum, they could have made that decision in 2022. And this is an important point.
The ordinance in 2008 could have been challenged at that time because it allowed up to 21 houses per acre, right?
Well, Your Honor, I think that is an interesting point. I think probably that would have been a legislative change. I think they were both challengeable as legislation.
Why would it not have been challengeable in 2008?
Well, Your Honor, it just because it didn't really make any kind of a decision is what I would say. But I would say ultimately I think both acts were referable. Even though I think there's probably a little better argument that the 2022 ordinance had more legislative oomph to it, if you will.
Let me explore that just a little bit. If the 2008 had just left two possible zoning options on the table, in 2020 they come in and say, yeah, we're gonna do both of those things. Is that challengeable at that point?
Your Honor, I think that the fewer initial uses they allow in the initial rezoning, I think it's kind of teeter-totter, if you will. The fewer uses they allow, the more likely down the road it's going to be an administrative decision. But here they allow any number of residences were permitted. The trial court only found that there was an upper limit. Well,
Are you saying they can never leave more than one option on the table with the initial, in 2008, they had to have limited it to one zoning category?
Well, Your Honor, even in workers, that wasn't sufficient because they did refer to one zoning district in that case, and the court still said, well, that leaves a whole realm of possibilities down the road. So the subsequent act was legislative. But no, I would say that if it's limited enough in what they do, or initially, there are some things they could do that further decisions, maybe a final development plan, something like that, where you've done all these things already that they were supposed to do in 2008. That could be administrative down the road. But as it is here, we never had a preliminary development plan either. We didn't have a density allowance. That is the meat of this case, the density allowance and the residential development plan. I mean, an upper limit, does one house per acre comply with an upper limit of 21 houses per acre? Yes. Does 21 houses per acre comply with it? Yes. Everything complies with this upper limit. It wasn't this range at all that the others.
That seems like a really good basis for challenging it in 2008, to say we don't want a development of up to 21 houses per acre, and we want to refer that.
Well, Your Honor, just because it could have been referred in 2008 doesn't mean that it shouldn't also be referable in 2022 because of the legislative decisions that were made. But the decision.
So let's say they'd said 21 in 2008, and then they come back and that's all it is. I think it does mean you can't refer it if they'd already said that and they're just coming in and saying, no, we decided that in 2008, so that's why it's administrative.
On that point, Your Honor, I think if they would have said in 2008, 21 houses per acre is what this is rezoned for. That would correspond to R2 under their zoning code. I think if they would have said that, that's just what the density is. I think that would take care of the housing density issue, and that would not. As it is, they didn't do that. They said, when we come back here, we can go with any one of the residential districts in our zoning code as applicable to this land because all we've done is set an upper limit. And they didn't even set an upper limit in 2008. All the existing code set that upper limit. And this, in fact, Section 125-194 of the old code, which is applicable at the time, said, the total number of dwelling units and the resulting density allowed in a pad shall be consistent with the land use plan of the city's general plan. The code already provided that, so they didn't do anything really in 2008 because the code, that upper limit existed by operation of law. So all these things that they supposedly did become illusory because if they wouldn't have said a thing in the 2008 ordinance about, well, we're subject to the general plan, they were already subject to the old code and the general plan. That's the law.
They did more than just say anything that's consistent with the general plan is fair game. There are some parameters, some architectural design requirements. It seems like they did some things and at least put in some parameters for future development.
Your Honor, I would agree. They did put in some parameters. I mean, they put in some setbacks. They had some direction on lighting. They did exclude every industrial district. None of the industrial districts were included in the old zoning. Basically, the original, the 2008 was anything outside of industrial, except for a few uses. I mean, you saw the way that Surprise, or maybe it was Truman Ranch, struggled to find the few things that you couldn't do under the 2008 ordinance. They said liquor store, but you can do that. You could do almost anything because it's everything outside of industrial, I think, other than this weird BP zoning district. But that's the key, is it wasn't specific enough, and that's even before we get to the preliminary development plan. The preliminary development plan is also a critical component just because of how broad the allowances are in the 2008 ordinance. And I referenced the old code. The old code itself stated it didn't talk about referring the pad it didn't talk about doing a legal protest against the pad. A legal protest is when a certain number of property owners say, well, I don't want this, and if they protest it, you have to have a 3/4 vote of council. What the actual old code said is if X number of landowners protest the preliminary development plan. I mean, it says preliminary development plan about 10 times in the old code. I mean, that's what the Planning Commission is supposed to make a recommendation on the preliminary development plan. Everything is predicated on that, and we didn't have that at all. So we end up in total with any number of residential districts and basically all commercial uses outside of industrial. So I think that the bottom line is whether the 2008 ordinance was referable, I mean, that was a rezoning, so it would have been referable, but I think clearly this action in 2022 is sort of the second part of that legislative act, because that's where the real decisions are made. That's what the arguments are about these days. Density is a huge issue to people. And again, if they would have gone from their old code residential zoning district of R1-12, that's essentially one house per 12,000 square feet, to R1-18, one house per 18,000 square feet, or vice versa, that would have been a zoning change, and that amounts to a minuscule difference. So if that's a zoning change, then making a decision anywhere from one house per acre to 21 houses per acre, I think is also clearly a zoning change.
Council, how do you define a zoning change?
Well, in terms of, and I think that leads us into the Winterstrom factors, a zoning change is, well, if they adopt a new residential zoning district, like let's say, Your Honor, if they go from C1 to C2, commercial 1 to commercial 2, then that's a zoning change. Actually, it's almost always a more intense use now as opposed to a less intense use because of Prop 207. But that's a classic zoning case. The difficulty here is because in a PAD, the actual zoning application is the zoning. It's not like you just refer to the zoning code to see what can I do in this district. You refer to the PAD. Now, that may incorporate certain zoning districts like this one. But, you know, in terms of what Winterstrom, I talked about how, you know, Winterstrom is good for maybe some general propositions, but it's best understood in the context of workers, which is why Surprise and Truman Ranch are trying always to get away from workers and take us back to this Mesa case.
You agree there are some different factors in workers that are not at play here?
Your Honor, workers is not directly on point, but I would say it's far more useful in terms of providing a framework. I mean, for example, we've got the 2022 ordinance. The first thing out of the Winterstrom box is the trial court said, well, this is limited because it only applies to the property. Well, every rezoning only applies to the property it rezones. You know, whether the 2022 ordinance is permanent, I mean, I don't understand that contention at all, that this 2022 ordinance isn't permanent. It's an entitlement. Workers talked about burdens and benefits. Clearly, that's the case here. Just go try and take away houses from this entity.
Your issue between the two cases is more the application, not the test. Am I correct?
That's right, Your Honor. But I think when it's analyzed in the case of a case about whether a road expansion, that was the Winterstrom one. So I mean, I think that's of limited use. And I think you run right into the limitations where you talk about, well, this only applies to a single property. Well, that's always the case in a rezoning. The 2022 ordinance creates rather than implements policy. I mean, I think I've talked at length about that already, but the one thing workers did say is the Tempe zoning code, quote, zoning designation contemplates future legislative acts. That's the case here. In fact, the 2008 ordinance
That's
requires...
only the case if we say they didn't specifically say if we want to have 3 different zoning categories. That would have been specific enough for you, or 2, and then they just go with those 2 uses.
They had to set a density allowance regardless. So that they had to do. I mean, these are things they didn't just
You say
contemplate.
They can't just implicitly do it by adopting just what's
That's
currently
why
available?
that's why they went to council. They never would have gone to council if they thought they could have just done it administratively, Your Honor. That's why it had to go through council, because it was a rezoning. So anyway, I think Workers does support, it's not on all fours, but I think it does support that, hey, you know, this is really a legislative change, because this is permanent, burdens and benefits apply, and also it contemplates, doesn't just contemplate, they needed a future legislative act on the part of council in order to actually develop this land. So with that, I'd like to get into latches. I think that obviously the Supreme Court remanded for a reason. The Dominium or Truman Ranch made the argument, well, hey, they're going to lose anyway. Supreme Court said no, they wanted to remand, and we think there at a minimum should have been an evidentiary hearing. We think we should win as a matter of law. One of the most troubling things about their position is that, you know, you can wait to assert claims until later.
Well, what exactly are you proposing the developers should have done, and when should they have done it?
Well, there's three things they should have done. I mean, well, the first one we don't really know, because we don't know what they knew when they knew, and that's why we should have had an evidentiary hearing on that. But
What if they knew the date that the client filed the petition?
Then, Your Honor, they should have sued. And I think that's implicit in the Supreme Court's ruling, because I think the Supreme Court's ruling assumes there's some set of facts that under which we would prevail. So if they know that day, why can't they sue that day? We sued in 4 days.
But that seems a little bit inconsistent with the court saying the city clerk doesn't have an obligation to tell you anything. Why does a developer, not knowing whether you're going to get signatures or not, they have to preemptively file a lawsuit if they find out that day? I mean, I can see it. Maybe I'm just making this up, but if the developer affirmatively said, yeah, we're not going to challenge that, we understand that, we've known that all along, and we're not going to raise that as an issue. Maybe that there would be a latches argument, but your argument seems to assume that there's an affirmative obligation on the developer's part to do something.
Your Honor, it's not an obligation, but the hypothetical I gave is, what if the city clerk got on the phone with them that day and said, hey, they didn't file their ordinance? It's not necessarily an obligation, it's what they knew and when they knew it, which is why we need factual development.
You're at your 4 minutes. Just to let you know that.
Thank you. I'll just go to 2. Well, real quick, but the other things they should have done is they should have filed a cross-claim after we filed our initial claim, so that all these things could have been decided at once. I mean, they said that themselves. They said, let's decide all these issues at once, so we're not here another year in this litigation. Well, they didn't do that, and so here we are again. All the while, you know, we're having to go through round after round of litigation. This court is having to go through round after round of litigation, and it's not just the voice of surprise that's the issue here. It's the voters. Sotomayor and Matthew talked about that. It's the signers, it's the circulators. All the while, the 2022 legislation remains on hold. That's probably the biggest reason we want to resolve these cases quickly. That legislation is still on hold. And if we buy into their argument, presumably if there's another remand, they can resurrect their argument they abandoned about the 200-word summary. There's no limit to it. So I think there has to be a limit. There's also the latches argument. They never named us as a real party in interest. And that's basically...
What's the prejudice on that?
Well, essentially what happened is the judge construed our answer, or excuse me, we never filed an answer, construed various pleadings we did as our answer. So we never got, we came in late, we never got an evidentiary hearing, and they admitted that this is a special action actually in their answer. So
not getting an evidentiary hearing is different than naming you.
It basically, the judge was forced to essentially not allow us to answer. And if we would have answered, everything on our answer would have been taken as true. So, I think that the bottom line here is that we need if someone wants to challenge something, they're two totally different issues. what the government's power is to disqualify referendum signatures and the rights of a private party. They took their chances, relied on the city of Surprise. I think they should be held to that.
But so you're saying they can't wait until after the signatures are gathered and then object and say you didn't comply and we've had this legislative directive that there be strict compliance. They can't just wait and look at it after the signatures have been gathered and say, well, there wasn't strict compliance, you should knock it out on that basis.
No, Your Honor, that's the whole laches doctrine, because people are out gathering these signatures, people are signing the signatures, we're going through a round after round of litigation, and the law is on hold. That's why you can't wait. We named them as real party and interests.
They weren't a named party at that point.
Yeah, yes, Your Honor, they were. They were a named party since the inception of this lawsuit, both Dominium and Truman Ranch, and they both made appearances. They both participated in the litigation. If they wanted to challenge this on a separate basis, they should have done so at that time. The alternative is we're sitting here a year later that they complained bitterly to the Supreme Court that, quote, this expedited election matter has already involved extreme delay, and that was in June of 2023. The reason there's delay is they didn't assert their rights. They took their chances relying on Surprise, and their argument failed, so they should be held to that, and we can't, in an expedited election contest, I mean, we just can't have these piecemeal arguments. I'm going to make this argument now. If that fails, I can always make the next argument on remand. I mean, if the thing gets remanded again, then they can assert another challenge under their theory. And there has to be a limit that the voters deserve it, the courts deserve it, the circulators deserve it. Thank you, Your Honor.
Good afternoon, Your Honors. Jeffrey Gross with Barry Riddell. Can you hear me?
Yes.
With the court's indulgence, I would like to split the oral argument between myself and the city. I will address laches, and the city, Ms. Bird, will address the administrative legislative distinction, if that's okay. Let me start with, just briefly, with where Mr. Lasota left off. And that's this idea that we waited, made one argument one time, another argument another time. Really, what this all boils down is process. We made the same arguments from the beginning of the case, even before the case was filed, in terms of what the deficiencies were. That the deficiency in the application was that it didn't attach a copy of the ordinance. That was raised from even before Mr. Lasota filed his case. So for him to say, well, we waited and raised different legal theories along the line is just simply not true. Let me delve into a little bit of more about what the laches argument is in particular, because it's hard to discern from the pleadings or the briefs, and Judge Catani, you specifically asked. Their laches argument boils down into two items. One, as Judge Catani said, we should have challenged the application for petition serial number when it was filed without a copy of the ordinance. That presumes we knew something about it, and Mr. Lasota says, well, we should have been able to have an evidentiary hearing on that. But there's no facts on the record, there's no allegations in their complaint that could be taken as well pleaded that either the private defendants, private parties, Dominium or Tatum Ranch had any knowledge. Mr. Lasota could have, but didn't, ask for expedited discovery before the hearing in 2022, before the hearing in 2023, to determine what, if it's even important, and I'll get to that in a minute, to determine what, if anything, Truman Ranch or Dominion knew. They didn't. So they're kind of stuck on the record now. There is no factual grounds on this record to justify an evidentiary hearing. But let's talk about that a little bit in terms of whether that's even relevant, what they knew or when they knew it.
Let's assume you knew on the day that it was filed. So did your client have an obligation to do something at that point?
No. Because the Supreme Court, as you recognized, and you're questioning Mr. Lasota, said that the city, and there's no doubt, it's on the record, the city knew, the city clerk knew that the application was deficient, that a copy of the ordinance was not attached. And the Supreme Court said, hey, city clerk didn't have an obligation to tell them. didn't have an obligation to inform voice of surprise that the application was deficient. Do we, as the property owners whose property is the subject of the referendum, have a greater duty? No, no case has held that. It doesn't make any logical sense. So we didn't have an obligation to object, and if there's no duty, it doesn't matter what we know. Second, so there's the objection element of that we should have objected. We should have said something. The second element of that, and what I get from their pleading, their briefs, is that we should have filed a lawsuit right then. That once we knew, assuming we knew, that the application was deficient, we should have filed a lawsuit, but right then, even before the signed petitions were filed. But that would have been premature because a lot of things could have happened. That's the very beginning of the process. After that, they had to go out and collect signatures. They had to file the referendum petitions. They had to then take them, process them, the city had to process them with the county recorder. Lots of things could have happened. Maybe they couldn't have collected enough signatures. Maybe they would have withdrawn the referendum efforts altogether.
Mr. Lasota also said that you should have filed a cross-claim and didn't. What's your response?
My response is that also would have been premature, and it would have been meaningless, because my understanding of the cross-claim is we should have filed the cross-claim after they've sued. So they sue. I think their complaint was filed in September of 2022. We should then have filed a cross-claim. We had our answer in cross-claim, assuming the cross-claim would have been filed, would have been due October 31st. Well, on October 25th, Judge Blaney set an evidentiary hearing for November 2nd. And on October 31st, the same day that our answer and counterclaim would have been filed, the parties did file memoranda, a hearing memorandum on the order to show cause for the November 2nd hearing. So these election cases, they're expedited. They are decided on an OS.
That hearing memorandum specified your objection based on application error?
Yes, I actually joined in the cities and Dominion's hearing memos, but that did specify that objection. So these cases, election cases, a lot of expedited cases are decided on the hearing memos. For us to file a separate appeal and counterclaim would have been meaningless. After all, we were named as defendants. And in the complaint, and I'll point you to paragraphs 28 and 29 of the complaint, the Voice of Surprise's complaint, they say, in response to the city's rejection of their petition because the application was deficient, and remember that even before this case was filed, there was an issue about whether the application was deficient. In their complaint, their own complaint, they say the application was not deficient. And then they name us as parties. So whether we file a cross-claim or not, we're entitled to defend on the grounds that the application was deficient. We did. Dominion did. The city did. The arguments, the issues were raised. There's another issue that would have made a cross-claim arguably frivolous, is because the city clerk had rejected the petitions. So what their position is that we should have filed a cross-claim under section 19-122C. Their claim for special action was under 19-122A to force the city to process the petitions. 19-122C creates a cause of action on behalf of anyone who wants to challenge them, challenge petitions, to enjoin, in this case the city clerk, from processing the petitions. Well, the city clerk wasn't processing the petitions. The city clerk had rejected them. So there was no reason for us to file a cross-claim. Could we defend on the grounds that the application was deficient to resolve that issue? Yes, we did. The trial court decided it. That issue went up to the Court of Appeals and ultimately to the Supreme Court. But it was raised every single step along the way as a legal theory. The fact that we didn't file a cross-claim is really superfluous because that issue was in front of courts at every level. And ultimately, the Supreme Court said it was not compliant with Arizona law. Therefore, law of the case, the petitions are invalid.
What in your mind would constitute a viable laches claim? What under what circumstances would you find laches?
The only cases that have found laches involved lawsuits filed too close to an election deadline. So, for example, Cromco case, I believe maybe the Sotomayor case involved, I believe, initiatives. And initiatives are a little different than referendum because initiatives, there are set deadlines. So the initiative is going to be on the next ballot. So there are deadlines. And in both those two cases, I know Cromco was one. I forget whether Sotomayor was or not. But in those cases, the lawsuit was filed days before the city or the state, the governing body, had to send the matter to printers to be put in the ballot. So if there is you wait too long before an election that has been set, and it doesn't give a court enough time to marshal witnesses, or of course, the parties time to marshal witnesses, decide on the merits, then there can be laches there. That didn't happen here. There's no indication that Judge Blaney was steamrolled. There's no indication that any of the parties could not marshal witnesses. We had an evidentiary hearing on November 2nd without objection. So there's just no evidence that there was any prejudice to the parties or to the electorate. Voice of Surprise has also complained, and I think you heard it, that there was prejudice because their motion to intervene wasn't granted until a few weeks before the October 23rd hearing. But we filed a cross-claim in August of 2023. The motion to intervene wasn't filed until a month later in mid-September 2023. Then the hearing took place on October 11th. There was no attempt to file a motion to intervene immediately when we filed the cross-claim, when we did file the cross-claim, because that's really when the cross-claim became relevant. When the Supreme Court said the city didn't have the power, the authority to reject the petitions, but private parties can bring those challenges. So that's when the cross-claim became relevant, when the Supreme Court said, no, city can't carry your water, you guys got to do it yourselves. We did it. And that's the only time that it had become relevant. But there was no prejudice to the Voice of Surprise in 2023 because they didn't object to the timing of the hearing, they didn't move for accelerated discovery, they waited a month to file the cross-claim, they filed provisional responses to the motions.
But you're agreeing that they should have been named rather than the city?
No.
Even though the city wasn't really an antagonistic party?
I am not. And we explained that in the motion why this is not a special action. The rules of special action don't apply. That's what they're hanging their hat on. This was a regular old action for an injunction under 19-122C. That injunction action is directed against the city. Specifically in the statute, it is directed against the city to enjoin them from processing the referendum petitions. And not, they might be a real party interest entitled to get involved. They could have done that, they did, and they were able to protect their interest. And with that, I think I will leave the remainder of the time to Ms. Berg, if that's fine.
Good afternoon. I'm Melinda Bird on behalf of the City of Surprise. And I'll just jump right to the crux of the Administrative Act versus Legislative Act issue, really getting to the residential density issue, because I think that's the heart of Mr. Lasota's argument. Judge Foster, you asked a question about how you would define a change in zoning, and I think the key word is change. And here we did not have any change in any of the entitlements on the property from the time the 2008 pad zoning was enacted to the time of the 2022 approval of the preliminary development plan. All of the uses that were allowed on the property were established in 2008, and the residential density that was allowed on the property was set forth in 2008, at least the allowable range of residential density. Anyone could have determined at that time by referring to the pad zoning, the zoning code in place at that time, which also referred to and incorporated the general plan, that they were allowed to build high-density residential development on the property with the range of 15 to 21 dwelling units per acre, which is exactly what was set forth in the 2022 preliminary development plan. All the preliminary development plan did in 2022, it's really just a site plan where it sets forth a diagram of here's where the different buildings are going to be, here's where the sidewalks are going to be, this is what we're going to sort of specifically build on this property. But it was all set forth in the 2008 pad zoning. There was no
Voice of
variation.
Surprise points out that the residential density allowance was missing in 2008, and the preliminary development plan was missing in 2008. What's your response?
The residential density was not missing in 2008 because, again, the pad zoning provided for mixed-use plan development as one of the uses. And if you looked at the zoning code at that time, it provided the different types of residential development that could be developed under that pad zoning, which did include high-density residential development. And there was a specific reference to the general plan in existence at that time, which said for high-density residential development, you could build 15 to 21 dwelling units per acre. So all of that was set forth in the 2008 pad zoning, and someone could have determined in 2008 that there could have been these 601 residential property units built on the property, which is exactly what was done with the 2022.
Could you have a pad in 2008 that simply said anything that was allowable under the general plan is okay?
No, I think that would probably be too broad, Your Honor, because you wouldn't have any set specific uses. You wouldn't have any sort of.
But you have specific, you're saying that it does set the density. You're relying on that for density, right?
Well, no, the mixed use, there was different residential ranges that were allowed under the mixed use approved in the 2008 pad zoning, and then the general plan had different units per acre that you could do under different residential densities. So again, nothing was exceeded in 2022. It wasn't like Mr. Lasota's analogy is that if the city had allowed, let's say, 2 houses per acre in the 2008 pad zoning, and then in 2022 we changed that. We allowed 3 houses per acre, or we allowed 4 houses per acre. That would be a change. That would be a rezoning. Here, the analogy is more that, let's say the 2008 pad zoning would have allowed 2 houses per acre or 3 houses per acre. They were both available under the 2008 pad zoning. And so in 2022, the property owners have decided to go with the 3 houses per acre option. It's not a change in the zoning. It's the same type of density that was one of the permissible densities in the 2008 zoning. So if someone
I
wants
take his argument, if it had said 3 per acre, and then they changed in 2020 to 2 per acre, it's challengeable because it's a change to the zoning, even though it's less, there's less density, but someone may prefer the 3 over the 2 for whatever reason. But so you can't do that. If it had been zoned for 3, you can't move it to 2 without being subject to referral. But if you say ahead of time it's either 2 or 3, then as long as you're saying as long as the developer chooses between 2 or 3, there's not a zoning change.
Correct. They were choosing one of the options that was already enacted via the 2008 zoning.
But that's, I guess, the question, can you leave every option open?
I don't think you could leave every option open. For example, if you didn't put any type of limitation on what uses were allowed on the property, then, somebody can't come in. I could see where somebody could argue if you come in 2022 and all of a sudden you were trying to put an industrial use or some new use that wasn't encompassed specifically in the earlier zoning, then that, again, that would be a change in the zoning, and somebody would have a right to challenge it at that time. But again, nothing occurred in 2022 that wasn't specifically entitled onto the property and contemplated in 2008. And on the flip side of
But Ms. Bird, I'm going to stop you just a second, because I think the crux of this case is, I agree with you, in 2008, all of these things could happen, and that's the word that you keep using is could. But what is supposed to put citizens on notice as to what is happening? And I think that's the crux of this case as we look at the Winterstrom factors, is in 2008, there was all of these things that could happen. It could be a Starbucks. It could be an apartment building. It could be just one house on an acre. When are citizens supposed to know exactly what the plan is? And is it not until then that they get to challenge it, or do they have to challenge it when they don't even know what's going in? I think that's the crux of this case.
Well, Your Honor, I think it would be a little too broad to say that it could have just been anything. Because back in 2008, in addition to the zoning, there was a
But correct me if I'm wrong. I mean, based on the zoning that's been approved back in 2008, this could be a Starbucks, it could be an apartment building, or it could be one house on an acre.
Well, actually, it was a combination of different uses that were planned back then. And that was all set forth in the stipulations, the staff report, the PAD narrative, all of which were incorporated into 2008 zoning.
But again, it could be any of those three things that I just named.
Well, it actually was going to be a variety of different items. But I guess here's my point. I think maybe we're on the same page, but just approaching it from different angles. If somebody had a problem with the sort of mixed-use planned development that was permitted by the 2008 zoning, they could have gone in and should have gone in and challenged it in 2008, because you were running the risk that, yes, it was going to be this multifamily, commercial, retail, residential. That was what it was approved in 2008.
But wouldn't you run into a defense that it's premature, it's not ripe, because we don't know what's actually going to happen with this land?
Absolutely not, Your Honor, because it was, as Mr. Lasota admitted, it was basically a legislative zoning. So someone could have come in at that time and said, we're not happy. We want to have single-family residential development. We're concerned about the potential development that could go into this property. And that was the time to challenge it. And when you don't challenge it then, on the flip side, it's very inequitable to the people who own the property, invest in the property. They're spending money getting, engineering studies, surveying studies, development plans. Property owners need to be able to rely on how this property is zoned to do the kind of development that was established via the 2008 zoning. So again, 2008 was the time to challenge that if someone had concerns about the permissible development that could have gone onto that property. And there's nothing in this 2022 ordinance that changes anything that was done in 2008, including right down to the architectural design, the setbacks, the building height limits. There were wall height limits. There was pedestrian walkway, landscaping. All of that was set forth in 2008, and everything in the 2022 preliminary development plan complies with all of that 2008 zoning.
All right. Thank you.
Thank you.
We did let you go over a little bit, and we will give Mr. Lasota, if you'd like, you could give him another 2 minutes.
Thank you, Your Honor, for that indulgence. So as to residential options, they did leave every residential option open, every single one of them, out of their 7 residential districts. It's easy to say in 2022 that in 2008 they would have allowed a referral. I don't think they would have, but that's easy to say now. And as to the developers and their rights, well, the old code called for the residential density allowance and the preliminary development plan to be adopted in 2008. They didn't do that. So if they would have done that, we wouldn't be here. So I don't think that's a sympathetic argument either. But in terms of the latches.
You're saying if they'd submitted one, but then that development fell through, you're saying that would change the analysis now when a different developer comes in?
Well, yes, Your Honor. If they would have done the residential density allowance and the preliminary development plan as the old code required in 2008, they never would have had this 2022 exercise at all. Now, in terms of latches, this notion that the the defendant made the argument they're making now from the inception is just baloney. The argument, the first round, was, does the city clerk have the power to disqualify these referendum signatures based on the application for the serial number? That was the issue. It was not an issue involving a private party's challenge to a referendum, as the opposing counsel says. Those are totally different legal theories. They involve common facts. Totally different legal theories, which is why the Supreme Court remanded. I mean, to hear Mr. Gross talk about it, that's the big question he leaves, is why in the world did they bother to remand the Arizona Supreme Court? Now, the other thing is this, the prejudice. Obviously, a big element of prejudice is going through round after round of litigation. I mean, we've had to win multiple rounds of litigation to prevail. Same for the courts. It's not just on the applicant. Voters are important also. The last thing on that we should have done expedited discovery, well, Latches was never relevant, the first round of litigation, because they didn't file an actual contest that would put the issue of what they knew and when they knew it at issue. Because they never filed a cross-claim. And it wasn't relevant this time. They didn't even name us until a party. We can't do discovery when we're not a party, and then they blame us for not intervening when even in their answer they admitted this is a special action. So with that, I appreciate the extra time.
Thank you to both sides for your argument. It's been helpful. We appreciate your briefing and argument. We will take this matter under advisement and try to get a decision out rather expeditiously, recognizing that we may not be the last word and understanding that you're under some time constraints. With that, we're adjourned.